The original title of this panel was, "Our Law Schools Operated as a Cartel." The title has been changed to be vacuous. I mean, American law schools, envy of the world or General Motors before the fall? Oh, really? I mean, that's a standard step in legal education, isn't it? And it allows a rambling and unfocused discussion. I hope that we can at least flutter around the original topic, because law schools are part of a system with large exclusionary features. Law schools cooperate with the American Bar Association and most states to reduce by 3 the number of years that anyone can practice law, and to charge a toll on the way. You can be a CEO, in fact, you can even be President of the United States without a credential. But you can't draft a will without a legal education designed to help you conduct a corporate takeover or counsel police on how to run a lineup. An economist would have no trouble identifying this 3-year education, much of it utterly useless to most legal tasks, as a means of raising rivals' costs, and thus of increasing one's own fees at the expense of consumers. Now, after Parker against Brown, there may be no judicial remedy, but the economic consequences remain. But the consequences remain inside the academy as well as outside. Since law schools are padded to fill out 3 years, it's easy to end up with a professorate that can indulge its own preferences. Amateur philosophers or armchair economists masquerading as lawyers. One test of quality in a legal academy, one might think, is whether people could get appointments in the real academic departments of the university to teach those things they most like teaching, whether it be economics or philosophy or psychology or sociology or history. And often the answer is no, they could not get appointments, which means that at least the "and" part of legal education these days is a lot of padding. Now, contrast the business school model. There's no license needed to conduct a business or practice consulting, and many people bypass postgraduate education in business. But there is a big demand for more formal education, usually 2 years' worth, but some students stay longer. But since the whole exercise is voluntary, education is much more rigorous in business schools, because if training isn't optimal, students quit or just shorten their stays. And in the business school model, the customer is supreme. It's more than a little odd, I've long thought, that the whole law school faculty should support the Supreme Court's decision in Virginia Pharmacy. Remember that? That's the decision which said that states have to allow advertising of any service that it's lawful for customers to buy, because you can't intervene in a paternalist way. The customer is king. But law schools and the ABA intervene in a paternalist way all the time to make it unlawful for people to hire to draft their will somebody who has only 1 or 2 years of specialized legal education, or, of course, like John Marshall, has no specialized legal education. Much of the legal academy went ballistic a couple of years ago over the Solomon Amendment, which had a trivial effect on how law schools operate. And you may remember that an amicus brief was filed in the Supreme Court by a very large number of Ivy League professors, articulating a theory of statutory interpretation that, well, to put it mildly, was ludicrous, and which all 9 justices rejected as something that, if seriously taught to the students, would just suggest that they were all guilty of malpractice. They were doing this, presumably, in order to protect the independence of the legal academy. But a cynic might ask why that outburst, yet calm acceptance of legal rules that require students to buy 3 years of whatever a law faculty serves up. And of course, the cynic wouldn't have much trouble answering that question by observing that the legal professorate supports whatever increases demand for their own services while suppressing competition from other means of training. Now, that has consequences, as I've suggested, both external from the consumer's perspective and internal. But you didn't come to hear me address that subject. Our panel today has 5 distinguished speakers, 2 of them deans, and one of those deans the incoming AALS president, and thus a potential lead defendant in some future litigation. Now, the program announced that there would be 6 speakers, but unfortunately, Rick Sander of UCLA can't make it because of an emergency. So we are down to 5, and they will speak in this order. The first will be George Shepard of Emory. The second will be Maimon Schwarzschild of San Diego. Rodney Smolla of Washington and Lee, that's our first dean, will be next. Paul Campos of Colorado is 4th. And John Garvey, the dean and incoming president, is 5th. And you don't see John. I'm told that he is on his way and will be here eventually, but it's a dean's prerogative not to listen to other faculty members speak. So he will be here eventually. Now, I could introduce all of these people, but you already know them, and I've already said too much, so I will yield. George Shepard. Maybe I ought to say that our understanding is that each of the speakers will talk for about 10 minutes. There will then be an interchange among members of the panel and then an interchange with the floor.
Hi, I teach in an ABA-accredited school, and today I'm going to talk about the union that has won me large salary increases and large increases in benefits. And to put it another way, I'm going to talk about the law professor cartel to reflect the original title of this symposium. And what I'm talking about, of course, is the ABA accreditation system. Now, the ABA accreditation system has some good impacts, and many of the people who run it are public-spirited and selfless, but all in all, the system has been harmful. The ABA system has become, in effect, a cartel of law school faculty and administrators, and existing law faculty have gained, existing lawyers have gained, but the losers have been students, universities, and other potential faculty members. The system prevents them from obtaining teaching jobs. The system has excluded many from the legal profession, particularly the poor and minorities, and it has raised the cost of legal services, and it has denied legal services to whole segments of our society. Let me just talk about a little bit about the technical aspects of what I think is going on economically with the ABA accreditation system, and I need briefly to mention the 4 markets which are touched by ABA accreditation. And the first market is the market for hiring law faculty and for hiring law administrators and law librarians. Here, a potential law teacher contracts with a school to provide her teaching and her scholarship and her prestige. In return, the law school offers her money as well as perks, a nice library, perhaps time off, a low teaching load. The second market is the market for legal training. Here, people who want to be lawyers purchase training from the law schools. The third market is the legal services market. Here, consumers purchase legal services from lawyers. And in all these markets, there's a potential for great diversity. For example, for law faculty, law schools might offer some faculty large amounts of money with relatively low teaching loads to allow them lots of time to do research. However, other law schools might offer contracts that require much more teaching. Or there might be some law schools that might offer people not very much money and lots of teaching. Who knows? The sky's the limit for the kind of arrangements that could be offered. But there, and for legal training too, as Frank has mentioned, that there could be lots of different ways of getting a legal education. You could learn it as an apprentice in a law firm. You could get it the way that is required now through 3 years in a law school, but there's lots of other ways that it could be done too. Now, but there's not much diversity in these markets, and that's because of ABA accreditation. And that's because the ABA system controls the supply. And the law says, and because the states enforce it, that you're only allowed to become a lawyer if you go to an ABA accredited law school, and there's these accreditation standards that are imposed to limit severely the diversity in these markets. Now, there's a fourth market too that I'd like to mention briefly, and that's the intra-university market for university resources. And I'll mention briefly later how the ABA accreditation system causes resources to flow from other parts of universities to law schools, but let me get to that later. Now, just also want to talk briefly just about the different ways of thinking about what the objectives are of a law school, because that'll be important for understanding the economics of what's going on. Now, some schools may operate like businesses, and this is the so-called proprietary model. They try to maximize their income and minimize their costs, like other businesses, but not many law schools run like that. Instead, I think it's easiest to think of most law schools as running like a partnership of law faculty. And it's the goals of these law schools are to maximize benefits for the faculty. There are no shareholders who get the profits. Instead, the faculty are the residual claimants of the operations of the law school. And so it's just like a law firm partnership. And bear with me as we go through this to see if this way of thinking about a law school is right. So in order to see why ABA accreditation runs the way it does right now, let's talk a little bit about the history of ABA accreditation. So, because the history shows what the real goals of accreditation have been over the years and how we might understand how history affects what's going on now. In the early 20th century, physicians really excelled at limiting the supply of new doctors. They, at one point in the early 20th century, imposed strong new accreditation standards and cut the number of medical schools in half and reduced the number of incoming doctors about in half. And lawyers were very jealous of this, and so they said, hey, let's do this too. And so until the Great Depression, there were really no educational requirements for becoming a lawyer. You could do it as an apprentice. For 100 years before the Depression, you could just apprentice in a law firm and then take a perfunctory bar exam and become a lawyer. Some people, just like the business school model now, some people chose to do it that way. Some people chose to go to law school. You could do it any way you wanted. But then during the Depression, lawyers and elite law schools finally succeeded in limiting supply, because during the Great Depression there was a downturn in the demand for legal services, so the existing lawyers wanted to limit the amount of new lawyers that were entering the market, and especially they wanted to shut down the proprietary law schools that had arisen in the earliest 20th century, mainly to serve minorities. There were a lot of Eastern Europeans coming to the New World and being served by these huge law schools. Suffolk Law School was the biggest law school in the country with over 4,000 students, a for-profit law school. And so in order to limit the competition from these new lawyers and for law schools, the existing law schools, to limit the competition from these law schools in the law school market, the existing law schools and existing lawyers thought a good way to do this was twofold. First, to impose strict accreditation standards to try to reduce the number of these law schools that were competing with existing law schools, and also to impose bar exams for the first time to impose strict bar exams. Until 1927, bar exams were not strict at all. They were perfunctory, and there were no accreditation requirements, no legal education requirements. You didn't even have to go to law school. You didn't even have to go to college. But then, during the Great Depression, the ABA was able finally to convince most states to require graduation from an ABA-accredited law school in order to become a lawyer. And a main reason that this legislation was sought, or from Supreme Court rulings was sought, was to reduce what was called overcrowding in the profession. That was the main reason for accreditation, was because there was too many lawyers overcrowding existing lawyers, and so to reduce this overcrowding, you wanted accreditation standards that would limit the number of law schools, thereby limiting the number of new lawyers. So, with that background, seeing that much of the impetus for accreditation was to limit the supply of lawyers, let's talk about the actual impact today of accreditation. No, first, procedurally, there's a bunch of requirements that one has to meet in order to become a law school. So, and before we talk about the procedure and substance, you can sort of guess what the nature of all the requirements are going to be from the fact that legal educators have captured maybe is a loaded term, have occupy most of the positions in the accreditation hierarchy. So first, there's many procedural requirements to become accredited. You have to file many expensive reports. You have to pay for site visits by the ABA. You have to be in operation for a year at least before you can even apply for accreditation. So you have to go through the dangerous expense of doing that, and with no guarantee that you'll be even able to operate after that. So the total cost of going through the process is several $1 million. So these procedural requirements operate as a stiff barrier to entry to new law schools. And then there's a whole slew of substantive requirements. And the underlying theme of the requirements is that they are a wish list for faculty. The standards increase pay and benefits and decrease workloads. And so give you a few specific examples. For a long time, there was official accreditation standards that required high salaries. Now, as part of the settlement with the Justice Department a decade or so ago, that was eliminated. But still, in practice, there'll be there'll be letters from the ABA accreditors saying that you aren't paying enough to be able to retain high-quality faculty. So, hint, hint, you should raise salaries. And the standards also limit teaching loads. They require hiring of full-time faculty and limit competition from part-time faculty. They require expensive offices and buildings and expensive libraries. The price of admission to accreditation is the common law is you have to spend at least $1 million a year on your library. And so the best way to look at the ABA accreditation system is a horizontal price fixing agreement among law faculty. It's a cartel of law faculty. In the ABA accreditation system, the faculty representatives who serve in the ABA accreditation system get together and agree on minimums for salaries and benefits for faculty. And the system enforces its agreement by boycotting any faculty member that agrees to lower wages and benefits. Suppose that a faculty member agreed to wages and benefits that are below the system minimums, then the ABA would act to eliminate her job. The ABA would not accredit the employer of this person, or the ABA would threaten disaccreditation. And the system also enforces its price fixing by limiting entry of new competitors. For the system makes it much more difficult, as I've already indicated, for new law schools to enter the market. Now, why would law schools and practicing lawyers agree to this arrangement where law faculty increase their salaries and benefits? Well, first reason for law schools is, as I've discussed, that they're this partnership model where they're really operating for the benefit of the law faculty. But second, the system also benefits law schools because it may have increased their costs, but it also eliminates competition from new competing law schools. So it's like if General Motors agreed to wage increases for the UAW, but in return the UAW agrees to arrange a boycott of the products of all the other car manufacturers. Now, why do practicing lawyers support the system? Because the system reduces the number of law schools, which reduces the number of new lawyers who enter the market for legal services. So, what are the impacts of the ABA system? Let's first look at the market for law faculty. It's reduced the number of jobs for law faculty, and it's increased the salaries of those who obtain the jobs and increased their benefits. And so, especially as accreditation tightened up since the early 70s, the salaries for law faculty far outpaced the salaries for other academics. And looking at the market for legal training, here it also reduces industry output, to put it in economics terms. It reduces the total number of student positions at law schools, and it does this by limiting the number of new law schools and by making it more expensive to set up a law school. And it also limits the capacity of each school. There are ABA standards that limit student-faculty ratios. So if there were no ABA system, there might be 50 more law schools serving students. And a lot of those would serve minorities because the ABA accreditation standards are set up in a way that has an LSAT cutoff, and certain minorities tend to, on average, score lower than non-minority students. So what, in effect, the ABA has imposed is a system that cuts out law schools that would serve majority, especially African-American law schools. So the limit on the output of legal education has had the expected impact on price. The ABA system causes the price of education to rise, about to double. If you look at unaccredited schools in California, their tuition is about half what it is for accredited schools. I mean, just think of it, $1 million a year budget for accredited law school. If you on average, that's about $4,000 per student just for the library that's required by ABA accreditation. And the system also prevents innovation. If there wasn't accreditation, then whole new forms of legal education might arise, but the ABA controls prohibit it. So the ABA permits only deluxe Mercedes or Lexus style of legal education and eliminates the Corolla style of legal education. And in the market for legal services, too, the accreditation system has stark impacts. It decreases the number of lawyers, increases the price for legal services, And why does the price increase? Because it increases the cost of becoming a lawyer and just increases the number of people who can become lawyers. So because of the accreditation system, you really can make a go of it only if you make more than about $50,000 a year, paying back your student loans, unless you're lucky to be financed by parents. And so it eliminates a whole group of lawyers who might otherwise be willing to serve for $30,000 to $50,000 per year. And so it means that in effect the lawyers are only available at more than $50 or $60 an hour rather than being available for cheaper prices. And so what in effect this means is that whole segments of our population cannot be served by legal services. Then just finally one comment on the inter-university market for funding. A common ploy that's used with the ABA accreditation system is as follows. I remember this is what happened the last time the accreditors came. Sat down with them at lunch and they say, well, what do you need around here? And you think, well, maybe a new library, or we need better faculty offices, and then you tell them this, and then they write it in the report and say, we are not going to accredit this law school again unless these new things are done for the law school. And so then the dean can walk across the street over to the administration and say, look, we're going to lose our accreditation if we don't get the new library or the new faculty offices. And if the president is a rube, then the president may fall for this and transfer assets from other parts of the university to the law school. And this commonly happens if the president doesn't keep his or her wits about him. So what should be done? If I was potentate, eliminate accreditation requirements. Make it like business school. Make it like engineering school. Make it like it was in the legal profession for 100 years before the Great Depression, which is often viewed as the golden age of the legal profession. And turn it back there. Let the market sort things out. People who need to do very complex transactions, well, they'll, as they did before, choose to go to law school. People who just want to draft wills might not go to law school. They might learn as apprentices. Or if you choose to go to law school, there would be cheaper law schools that would be available, perhaps 1-year programs, perhaps 3-year programs, perhaps 5-year programs. The market would sort things out, and there would be cheaper legal services available for many people in our society. Thanks.
Thank you very much, Professor Schwarzschild. But before we move on, surely the dean of the law school would have an ethical obligation to alert the president of the university to the fact that this is all a ruse, wouldn't it?
On that word ruse, we turn to me. It is, hi. It is, I think this is a fairly unsurprising story, both from Professor Shepard and I think from many of the rest of us, of benefits and costs. This particular story may also be a story with some prospect that greed may kill off a good thing. Perhaps a better thing than either Judge Easterbrook or Professor Shepard at least seem to be acknowledging that we may be in the process of killing. The story of American legal education, as just reviewed, is, I think, pretty well known to most here. Especially in the 30s, the organized bar, without objection, of course, from the higher education industry, lobbied through a requirement in almost every state that you have to have a law degree from an accredited law school to be eligible to take the bar exam. Until the 1970s and even later, most law schools were academically and intellectually not burdened by excessive ambitions. The teaching was doctrinal. Faculty scholarship wasn't a priority. There was very little interdisciplinary academic work. Even the best law schools weren't necessarily intellectual hotbeds. But there was an enormous gap in terms of scholarly activity and ambition between the best law schools, Harvard, Yale, Chicago, and a very few others, and all the rest. In the 70s and 80s, that began to change. More and more law schools, nearly all of them really, began to encourage faculty scholarship, publication, and a more academic style. Smart, intellectual, academically ambitious faculty were hired at law schools where they would have been out of place in the past. All of this costs money, and it was mostly paid for by tuition money, eased, of course, by the legal monopoly the law schools have on access to the bar exam. But until the 1980s, tuition costs didn't go up ahead, or very much ahead, of the general inflation rate. What you had was a rise in intellectual standards and a democratization upwards of legal education. What had been confined academically to Yale and Chicago and Harvard and a few other places